before the council by which on the basis of the complaint. Leaving aside every other thing, in my response, your lordship will immediately pose this question. In my response, I specifically seek a copy of the complaint.
Page 50, by your way of page 50, where you directed to give a response.
Yes.
Where is it?
Give you notice, considering the and upon the result of the available records.
Where are you reading? Where are you reading? Page 50.
Page 50.
You are hereby requested to bring the certificate of registration in original and to submit the same before start of hearing, failing which your case will be heard ex parte. All right. So you are requested to bring the certificate of registration in original.
Yes.
Thereafter,
I give a detailed response to this, including please see page 60. Apart from anything else.
Page 52. It starts.
Yes, it begins at page 52. It ends at page 68.
All right. Your response, yes.
So the paragraph 6, the page 60, last paragraph. So the suo motu proceeding as per charge sheet surprisingly transferred to a proceeding which has been initiated based upon a complaint made by someone of which I have no idea or no copy of the complaint till date has been made available to properly defend myself by the council. It is not only very confusing but subject matter of grave suspicion of a greater conspiracy and a charge of shifting the stand in a whimsical and pure sign of malpractice. Apart from this, I raise various issues including the fact that what is this qualification about? If your lordship sees the degree, page 30. But it is a distinction. This is Royal College of Physicians, Surgeons of Glasgow, having acquired distinction as a physician, was on the 2000 admitted a physician fellow of the Royal College of Physicians and Surgeons of Glasgow. Nothing else.
Oh, what does this mean? Did the candidate pursue education over there, attend college, online, or what?
On the basis of whatever he furnished from here.
Wow, furnish what? Thesis, paper, dissertation, something.
Including his acumen in practice, his proficiency in practice. Considering that, this is done.
So this is not a regular educational certificate type of thing.
This is not a regular educational. This is not a not a qualification person.
Not qualification.
It's an honor.
All right.
It's an honorary title.
Right.
It can be construed to be that.
All right. And how much weight does it carry?
It is just a feather in the cap, if I may say so with greatest of respect. It doesn't carry, it has got no semblance of, coordinate.
And does it,
feather in the cap, to ordain the letterhead. Apparently, my understanding is it does not add any extra value to his proficiency as a doctor.
Qualification. And this certificate is not used for his treatment or nothing of the sort.
Treatment?
Very well.
Yes, he is a radiologist by profession. He is a doctor.
That must be because of a qualification that he obtained by studying. Exactly.
Yes. Now, this being the position, this is the ultimate decision under challenge at page 12. Apparently the supplementary affidavit is just to bring on record this, including adding these points that it is bereft of any reason. No reason, no consideration worth its name has been given to whatever. It merely records the ipse dixit of the authorities. It does not allow a peep into their mind as to why whatever explanation.
Yes, I get it.
Was not
I get it. Right. So is this a ground of challenge?
This is prima facie. Right. But I will be requesting my lord to kindly interfere at this stage. My entire what they have done, what they are doing, though this issue is ancillary to it. It is recorded in the supplementary affidavit. Though this issue is ancillary, these persons, there are certain people, who are hell-bent in seeing that somehow I am shown the door from IMA and I am castigated by the entire world for having done something which I have not actually done. So kindly protect me,
is the person an independent private practitioner? Is he government attached to any government hospital, or
he is a private practitioner?
Private practitioner. All right.
Completely a private practitioner. He attends like chambers.
Yes.
And if your lordship wants, I can cite judgments, just to prima facie.
Yes, please. First thing, unreasoned order. Second is copy of the complaint that you rely upon, not furnished. Any, what are the other languages used? Page 50.
Page 50.
Page 50. Information and evidence that you rely upon at the time of passing the order not communicated. Your response.
First is, my lord, what is the admitted case? 2019, please have a look to page 30. My learned friend has placed that. Kindly comes to page 230. I'm sorry, 200, only 30.
Yes. The certificate.
This is the certificate. What is very important is, your lordship will find at the top, Diploma of Fellowship, FRCP, Glasgow. Diploma of Fellowship. The admitted case is that this is an honorary degree. Where do I get that? Paragraph 6 and para 16 of the writ petition. Admitted. It is obligatory for a medical practitioner to inform the authority about his additional medical qualification and asking for registration of the same as per rule. And it is obligatory and strict duty of the authority to record and register the same without any delay. Therefore, registration, according to him, is a requirement. According to him, counsel was sitting tight. Good but indifferent, this is the case made out. Now, whether, my lord, this can permit him to use the qualification. My learned friend was asking for a complaint. I'll answer that. What prejudice is he suffering? Because it is his case that he has applied for registration, verification done, not rejected, therefore he's not communicated, therefore deemed not rejection, in the active way deemed permission. This is what is his case. Now, my lord, we go and my lord, give him a charge sheet. Now, the language of the charge sheet is very important. Please take me to page number 50, 50. But in the highlighted portion, I will not trouble your lordship with it in its entirety. Please take the fourth paragraph in the highlighted portion.
Yes.
In your letterhead.
Hmm.
In your letterhead, you have never disclosed your additional qualification diploma of fellowship so and so. To misrepresent the patients and the general public at large, you didn't mention diploma of fellowship FRCP Glasgow. As your additional qualification, you only mentioned FRCP Glasgow is your additional qualification in the letterhead. The act and actions of yours as a medical practitioner is violating Rule 26 of etc. Misrepresentation of your additional qualification amounts to an infamous conduct in professional respect. But the charge is that only saying FRCS Glasgow gives an impression to the general public that you are a degree holder. You ought to have written diploma and fellowship, then FRCS, so that the public, because he has mentioned specifically that when we go to a government hospital, we don't look into the doctor's qualification, or rather we are not in a position to ascertain. But when we go to a doctor, we try to ascertain what is his or her qualification. Now, if I go to this doctor, I may be misled that no, he is a degree holder of the Fellow of the Royal College of Physicians. Therefore, this is an additional qualification. He must be a good doctor, a better doctor, or more having more degree than any other MBBS. Now, this is the charge against him. Then please take me his reply to it at page 52. It's primarily, my lord, the reiteration of the previous letter. Again, we are at page 54. He says,
Learned AG, please confine your submission to this as to what will be your answer to the point that has been raised that the order impugned is a non-speaking one.
yes.
Please.
My lord,
These things are already there on record. Your authority could have passed an order by taking all these things and then pass an order.
could I say this? Could I
Yes,
say this?
please.
Number one, my lord, he knows what is the charge against
He
him.
may know it.
Yes.
But then for him to go in appeal, what will be his grounds of appeal? There is an appellate forum.
Yes.
But the court
But
is
that is my
interfering.
point. But
The
that
court
my
is
point.
interfering only because it happens to be a non-speaking order.
But may I say this? Number one is, where a non-speaking order by itself is no ground to for interference. Why I say this? Where my learned friend's client has to show prejudice. The prejudice
Yes.
test is what your lordships have embarked upon when somebody comes and alleges breach of natural justice.
Yes.
Therefore, my lord, my learned friend should demonstrate before the court that how is he prejudiced by the so-called non-speaking order, because he has been told that this is the charge. He accepts that he ought to have registered this. He accepts that he had applied for registration. Now, if he has applied for registration, the minimum that is required is that registration is to be granted.
You never know whether there is a requirement of a registration or not. The court at this stage will not go into it at all.
Yes.
Thing is, you say Tell me, this certificate at page 30, the date appears to be 2019.
2019.
We are in 25.
Yes.
And since when is he using this nomenclature over there?
6 years.
But maybe 6 years. But Miller, today Miller,
6 years?
yes.
It didn't come to your knowledge?
No.
It must have come to your knowledge by way of a complaint or something. Though you say
No
suo moto,
complaint. No complaint.
it comes to your knowledge suo moto.
Miller, your lordship, Miller, this comes because according to him, he had
No,
applied.
not according to him, according to you. When did it come to your knowledge?
Miller, please take Miller his paragraph, page number 7 at the top, or page number 6 of the writ petition, last line. Or the last 4 lines.
What
assume
is it?
for argument's sake, whatever he is saying is correct. Please take page number 6, the last 4 lines.
Page number 6. Prior to issuance,
Yes, that prior to issuance of the show cause notice, the petitioner was asked by the respondent number 2 to get the FRCP registered with the respondent number 2 as an additional qualification. Consequential to the same, the petitioner made an application on 3rd of March and the respondent herein took an amount of so and so for registration of the additional qualification. Therefore, it is his case that a registration is required.
No, but then it is also his case that he did it pursuant to the direction given by the respondent number 2.
Yes, somebody may have advised him
Right.
that get it registered.
So this person is using that nomenclature since 2019 till 2025.
But if it is an infamous conduct,
Yes.
then Miller, the infamous conduct continued for 6 years.
Right.
Now, please consider, Miller, this infamous continues every minute, every second.
Yes.
It continues today even.
Right.
From the documents on record, it is available that at least from 2024, my learned friend says 6 years, 6 years, let us assume for argument's sake, Miller, the fact that he has been using it for 6 years will not, Miller, prevent me from taking any step.
Yes.
Provided he says that no, it is not an infamous conduct. That
Provided
is not.
provided you give him the reasons for taking the steps. Certainly you have a right to take
Yes.
steps for any infamous conduct as per the act.
Yes.
But let the person know that what is the ground for which he can prefer an appeal before the appellate authority.
But the ground
What
is
I
easy.
intend to do,
Yes, Miller.
let me make my mind clear and thereafter you all can make submission.
Yes.
The issue is with regard to page 30. The letterhead of the petitioner, there is a mention of FRCP Glasgow. Let it be mentioned as diploma of fellowship such and such as appearing in the certificate itself. Now what this will go to the public, how the public is going to take it, does the general people know that there is a difference between a degree or a diploma? I do not know. As an advocate, as the Advocate General of the state, you may know that there is a difference. There may be many out here who may know, but general public, how much they will know, I do not know. There is the certificate mentions diploma of fellowship such and such. Let he use this. You will be given permission to conduct the proceeding in terms of the act. Give him the reasons that these are the reasons. Thereafter, whatever is the order, provision for appeal is there.
But may I, Miller, only react to this
Yes,
in
please.
this very humble way?
Yes, please.
But the reason that I'll give is in the charge sheet itself. And
Maybe there in the charge sheet, not reflected in the order sheet.
can you consider this, Miller? He is aware of the charge,
Maybe.
but he doesn't deny.
Please, no.
But I try to find out. I
No.
try to find out, Miller,
No,
from
no,
the
no.
petition
Yes.
that he has said.
He may know a lot of things. Why will it not go down in the order? It is only
Please
for this
consider what
reason.
Miller, the reasons may or may not be there, Miller.
And thing is,
Yes.
he is using this for 6 years. You conclude the proceeding in accordance with law at the earliest. And he is during the period that you will conclude the proceeding, he will use whatever is there in the certificate.
But that will, Miller, that will not do away with the wrong that he has done.
Maybe,
Yes.
but then you say he is using this as a qualification without
He says,
registration.
I'm not saying
Or
that.
whatever. Now, whether please come. And what about the communication? You do not communicate the order to him.
As per the rules, Miller, it has to be gazetted. The gazette notification has been done.
All right. And
No, communication, he has annexed it.
no, he has not. No communication.
Acha, after.
Fine. Caveat page, chota fine.
But my instructions are that it has been dispatched.
Maybe he'll receive it.
Yes.
But then this has come prior to that. Please come.
But is your lordship's pleasure to dispose it of?
Absolutely. I'll give you the liberty
Just
to proceed.
Give me a moment to take instruction.
From whom? No, you are the all in all. No taking instruction and no consultation. I give you liberty.
No, the instruction which I would require is from which stage should I start?
What I would propose, you have given the charge sheet and a reply is there. Start it thereafter. Give him a hearing, or if the hearing is there, hearing is over.
Yes, yes.
Hearing stage is over.
During the hearing, on the 3rd of July, they gave me questions. But the questions and the answers are appended here. No consideration thereof.
No, they'll consider in their final order. If the hearing is over, then you
Upon
can
giving an
pass it
opportunity of hearing to explain myself.
further opportunity.
Yes, another opportunity. Because my specific stand is, this is not a degree. Whatever stand might have been taken, in the last representation, I have taken this specific stand.
In
You are
all
not
along, in
you are
your
not satisfied.
communication,
I
you
was
have
telling Mr.
mentioned,
Chakraborty also that in the initial stages of the reply, even against 9th June, the language is little different. But starting from page 67, 66, kindly sees the response.
thereafter the legal advice came in a different manner.
Whatever we
I don't think there was any legal advice.
Previously may not have been, but thereafter something
He has deposed before the authority.
Yes.
Of the committee.
Whatever is there.
There, at page 75 of the writ petition.
written communication.
Please come.
Written questions.
Written communication, whatever. Yes.
The petitioner has averred in the writ petition that he is a medical practitioner and he holds the degree of MBBS and DMRD and has been honored FRCP within bracket Glasgow and FIAMS. Stop. He claims that he is the secretary of the Indian Medical Association and the member of the MAC National Medical Commission. Stop. He is aggrieved by the order dated 4th July 2025 passed by the West Bengal Medical Council, whereby he have been found guilty of infamous conduct in a professional conduct in his profession, and decision has been taken by the council to remove him from the register of registered medical practitioners maintained by the West Bengal Medical Council for a period of 2 years from the date of communication of the order. Stop. The learned advocate representing the petitioner submits upon instruction that the impugned order is yet to be communicated to the petitioner. Stop. The petitioner got to learn about the order from the official website of the medical council. Stop. Paragraph. The very first point of attack is that the impugned order is a non-speaking one. Stop. No grounds and or reasons have been mentioned by the authority for removing his name from the register of medical practitioners. Paragraph. It has been submitted that a show cause was given to the petitioner on 9th June 2025, which the petitioner responded on 23rd June 2025 and responded on Apple by filing a detailed answer. Stop. In the impugned order, none of the explanation given by the petitioner has been taken into consideration. Stop. Next. The nomenclature in the letterhead of the petitioner, which gives rise to the instant proceeding, mentions that the Royal College of Physicians and Surgeons of Glasgow offered the diploma of fellowship within bracket FRCP within bracket GLASG bracket close. The learned advocate general represents the West Bengal Medical Council. Stop. It has been submitted that the charge sheet is a detailed one and the petitioner is aware of all the charges leveled against him. Stop. It has been submitted that it is the admitted case of the petitioner that the diploma is a qualification for which the petitioner applied for registration of the same. Stop. Next. The communications made by the petitioner in response to the show cause notice.
One thing it needs to be shown. I have said that it has been verified. That document I have craved for kindly, it is also there.
What thing?
It has been verified by the council.
Which document? Page 30? Page 50?
That page 30 is
30.
something which is genuine, or it has been verified by the council upon my making the application.
No, how does it matter?
Well, she wants to.
Because that is not the allegation.
Yes.
Is it say no?
It does not say.
I didn't see that it mentions fake or it is
No,
not.
it is not a fake.
কি বললাম?
The communications made by the petitioner in response to the
Also mentions the said diploma as a qualification. Stuff. It has been submitted that the general public may be misguided and misdirected by observing the by observing the description of the doctor as reflected in the letterhead. Stop. It has been argued that the petitioner will in no manner be prejudiced if the reasons are not disclosed in the impugned order. Stop. Next. I have heard the submission made on behalf of both the parties. Stop. The submission of the learned advocate general that the petitioner will not be prejudiced cannot be accepted by the court. Stop. The delinquent is certainly entitled to know the reasons for which he is being removed from the list of register of the medical practitioners. Stop. The subject qualification, the subject, the mention of the diploma is appearing in the letterhead of the petitioner for the last 6 years. That is from the date of its issue in the year 2019 till the show cause notice is issued in the year 2025. Stop. If the authority intends to prosecute the petitioner, then proper reasons ought to be mentioned in the impugned order so that the petitioner may challenge the same before the appellate authority. Stop. The impugned order discloses the appellate authority but does not disclose the grounds on which the petitioner may move the appellate forum. Stop. Paragraph. Without entering into any further details, the court is of the opinion that the impugned order is bereft of the grounds on which it has been passed, can be treated to be a non-speaking and a cryptic order and is liable to be set aside. Stop. The impugned order is accordingly set aside. Stop. The petitioner, however, is restrained from using the expression FRCP within bracket GLASG in his letterhead until further orders. Stop. It will be open for the petitioner to use the expression
diploma of fellowship FRCP
as mentioned in the subject certificate, that is diploma of fellowship FRCP within bracket GLASG.
Yes. Yes.
ঠিক আছে? The medical council is directed to forward to the petitioner any information, evidence, the complaint or inquiry report based on which the show cause notice and the impugned order dated 4th July 2025 has been passed and give an opportunity to the petitioner to respond to the same. Stop.
Yes.
An opportunity of hearing shall be provided to the petitioner. Stop. A reasoned order shall be passed by the authority at the earliest. Writ petition stands disposed.
Yes.